Minister in the Office of the Attorney General.
Mr. Vice President, I thank you most sincerely for the opportunity to contribute to this debate. You know, for the benefit of the listening and viewing public, what is amazing to me, and I'm sure all of my colleagues in the Senate who would have done their homework in preparation of this bill, what is amazing to me is that in 2012, Mr. Vice President, there was a World Bank report entitled The Promotion and Service of Foreign Investment in Trinidad and Tobago. It was also called a Way Forward Volume 1 Executive Survey. And in that particular report, the World Bank made recommendations to the then government, which is the UNC government, of the inefficiency policy framework that existed in Trinidad and Tobago. They identified a weak legal and regulatory framework system. That report identified poor reporting by existing zones. It reported and identified a need for new policy to modernize the development of SEZs in Trinidad. All of this form part of a report that was presented to the United National Congress when they were in government in 2012. Now, I could understand 2010, you're now relishing and enjoying coming into power. 2011, I believe, so nothing happened, of course, relative to that report. The report was not in existence. 2011, there was some amendments made to the Anti-Terrorism Act, Chapter 1207. But, Mr. Vice President, 2012, based on the recommendations of that report, nothing was done. 2013, based on that recommendation, nothing was done. 2014, they were still in power. Nothing based on that recommendation was done. I could continue until their power came to an end. So it is absolutely amazing to me when members of the opposition come here and most respect, they present, they speak as a champion for the grassroots and a champion for those persons on the ground. But yet history dictates that when they had an opportunity to serve those who were really on the ground, what did they do? Absolutely nothing. And I want the people of Trinidad and Tobago to be minded of this. Now, Mr. Vice President, the Honorable Senator Naked, he asked the question about consultation. I heard consultation about 20 times in his presentation. Where was the consultation? Well, I will say to Trinidad and Tobago, and I have to congratulate the Minister of Trade and Industry as I begin my presentation in this debate, because consultation, I will tell this Honorable Senate, and I will tell the people of Trinidad and Tobago where consultation went. In 2017, it began. It began under this Minister of Trade and Industry. It began with what? The Organization for Economic Cooperation and the Development of OECDs. That was consultation to make sure that this bill that we presented today was compliant with that framework. We had to also, consultation took place because we had to ensure that it was consistent with base erosion, profit sharing, inclusive framework. Consultation took place there. Consultation took place because we had to ensure that this policy, this bill that appears before us, was consistent with the European Union Code of Conduct Group. Consultation took place there. We had to also ensure that this bill that appears before us was consistent with the revised Treaty of Chaguaramas, in particular, Article 239. So consultation took place there. So respectfully to the Honorable Senator, consultation, this is consultation. Trinidad and Tobago, I want to say to you, this government we recognize is not a parlor we run in. And because it's not a parlor we run in, we understand that it takes time to try to get things right. And as a consequence, from 2017, the minister with her technocrats, together with the Attorney General, Minister of Finance, Prime Minister, have been working assiduously to ensure that the bill that appears in this incarnation, in the incarnation that appears before this Honorable Senate, can stand the test of scrutiny. So, Mr. Vice President, I hope respectfully I would have answered the concerns of the Honorable Senator, Mr. Naked, who was very much concerned about consultation as it took place in the creation of this bill. Now, The crux of my presentation, if time permit me, Mr. Vice President, I may want to look at the role of inspectors as it exists in the bill that appears before us. And again, if time permits, I would want to also focus on some of the offenses that are created under this bill. But before I do that, respectfully, there are certain points that has been placed on the record, questions that were asked by honorable colleagues in the Senate, and I'm sure the Minister of Trade and Industry, in her winding up, she will deal with the majority of it. I know the Attorney General will join in this debate, and he too would add his expertise, but there are certain points that, at least I believe that I'm positioned to be able to make a contribution, and those were the points made by other senators. Now, I would firstly like to respond to certain questions, a few questions that was asked by the Honorable Senator, Ms. Jolene John. I must say for the record, Mr. Vice President, at least at the time that I have been in this Senate, I've always enjoyed Ms. John's presentation, particularly because she does not relegate to gutter politics. And it's usually a contribution that has some kind of substance, some kind of intellectual substance. So I have to identify that. But the learned senator asked the question whether in some of these compliance, what are the advantages and how is this impacting negatively or positively on Trinidad and Tobago? And I would rather focus on the positive implications, and that was in dealing with the topic of blacklisting of Trinidad and Tobago. And of course, the honorable senator asked that question. Now, Mr. Vice President, and especially for the benefit, and I'm sure this is not something new to the Honorable Senator because clearly she is, very versed in this area. Compliance, Mr. Vice President, it creates an avenue for integration in the country's financial system, especially in the global financial system as AML preventative measures, as we know, such as customer due diligence, identification of beneficial ownership of financial assets, and suspicious transaction reporting, we know can definitely impede tax fraud and, of course, tax evasion. So if we are to ask what are some of the advantages of being compliant, there we have it. Also to the Honorable Senator, looking at its impact on Trinidad and Tobago and the advantages of being compliant, we also have the protection of the integrity and stability, Mr. Vice President, of the international financial system, and the SEZs would then benefit as their aim of attracting new and foreign business and business of a different caliber, Mr. Vice President, will be done. I also want to add for the record, according to the national SEZ policy, improving worldwide compliance with AML and CFT standards benefits the entire international financial architecture, as which we know is very important to Trinidad and Tobago, having had setbacks in financial trade relationships arising out of said blacklisting. Finally, to the Honorable Senator, strong AML CFT controls increase public confidence in financial institutions and national systems, and of course they promote the integration of markets and investment through cross-border financial and direct, of course, foreign investment. So this was just in response to the Honorable Senator question as it relates to how will we benefit by ensuring certain compliances within the regime or within the structure of this bill. Now, the Honorable Senator also asked a question, how are we attracting direct foreign investment while we adhere to all of these measures? And to be quite honest, this was one of my concerns as well when I had a look at the bill, because, you want to ensure that, you crack down on money laundering, you want to make sure that you crack down on all of these white-collar crime as it exists in the zone, but at the same time, you want to make the climate attractive for investors. Sometimes you go to apply for something, and when you look at the form alone, and this is for the benefit of for the persons on the ground, you look at this form alone, and the form turn you off, and you decide, nah, I'm not even bothering to apply for this grant. So I understand where the senator is coming from, because really and truly it was a concern of mine, especially for those smaller businesses who may want to operate in the zone. But unfortunately, as a responsible government, it is a balancing act that we have we have to focus on. So while we introduce stringent measures in order to monitor and manage any white collar crime that may be in existence in the particular zones, in the zone, what we also have to do, what we have also done by virtue of this bill and the policy that this bill was predicated upon, is also introduce a lot of incentives, with the hope that the incentives will far outweigh the task of persons understanding that they're being monitored and all of that. Some of the incentives, now the types and levels of incentives are magnanimous in accordance to this. If we look at the bill, we have time periods in which these incentives are offered, which we also hope is attractive. The nature of incentives, if you look at the bill, there are financial and non-financial incentives offered. We also have locational specificity of these zones. So we are hoping that this would have created the balance which is much needed in managing the zones, ensuring that we clamp down on any existence of white collar crime or any sort of criminal activity within the zones, but at the same time incentivizing it so people can still be attracted. Now, the Honorable Senator also asked a question, and as it relates to the topic of gross negligence, she was focusing on Clause 19 of the bill. And the question was, now, who, Mr. Vice President, decides on whether something is grossly negligent, right? Now, to answer the Honorable Senator, I want to take the Honorable Senator to Clause 15(2)(b), F, and G of the bill, which says, the board may, by instrument in writing, remove the Chief Executive Officer from his office, and that those clauses go on to speak to the board having the responsibility, of course, to discipline the CEO of a company, of the authority. Now, looking at 15(2), Mr. Vice President, of the bill, this determines, we can see it's really the board of directors, as I indicated before, determines whether we have, whether an act by the CEO would be deemed as gross negligent. And also to answer the Honorable Senator's question, there's reason why, Mr. Vice President, we have not been too prescriptive in this provision. And the reason for that is because certainly we do not want to run the risk of infringing on the separation of powers. That is the role of the judiciary along with the role of the legislature. So what you would also find, if I may also respectfully take the Senator in answering that question, we can also turn to other pieces of law, because the existence of this bill does not eradicate the existence of other existing trade law in Trinidad. So for example, if we look at Section 30B of the Companies Act, we know not to conflate the CEO and the chairman as they are treated as two separate entities. Also, if we look at Division 4 of the Companies Act, Mr. Vice President, this spells out offences and penalties, specifically Section 523, I believe, which empowers the court to grant relief in certain cases, such as negligence and a breach of duty. Therefore, Mr. Vice President, to answer the Honourable Senator, we also have the court can make the ultimate determination on whether an act committed by a CEO or an employee amounts to gross negligence. So there was no need for us to be prescriptive in this bill when there are other trite pieces of law in which a CEO, any gross negligence that occurs within the authority can be dealt with. Now, even if we look at the Industrial Relations Act, if the allegations that are made or the case that appears can fall within the parameters of what relief the Industrial Relations Act provides, that is also another piece of legislation that can work in tandem with the bill that appears before us to deal with issues of gross negligence. So I had some more comments I wanted to offer, but I know for the interest of time, I would have to move on. If I may now respectfully turn to Senator Leiter, there was certain, the Honourable Senator, Mr. Vice President, in his contribution, he made the point the government's track record does not instill confidence in the ability to deliver on aims and objectives of this proposed bill. Senator Leiter commented specifically that Clause 5.1 gives the indication that the government failures of this government's failure, where he made a reference to the words, the bill develop modern infrastructure required to attract foreign direct investment and stimulate domestic investment. Now, Mr. Vice President, in order to determine, firstly, whether this government instills confidence in the ability to deliver aims and objectives of the SEZ, we must look at the present law which currently is in operation. So when Senator Leiter makes reference to a clause that has not yet been cemented into law as a result of it yet not going through the parliamentary process of a vote, with someone who I would expect who has been sitting in Parliament for the past year on the opposite end should have an understanding. In this regard, I recommend that the Senator revisit the basic principles, Mr. Vice President, of parliamentary procedure, because certainly he's in no position to speak about our failure and the failure of this bill, it having not been operationalized to date and still presently on the floor of this Honorable Senate. Now, Mr. Vice President, if I may also add or contribute to another point made by the Honorable Senator. He made reference to Schedule 4, which contained the criteria, one of which is that the number of full-time qualified employees physically present for large enterprises to be at least 50. The Honorable Senator also proposed an amendment that the language does not require 50-plus staff to be physically in the zone, but rather staff to be actively located in the zone, whether remotely or in the zone. Respectfully, I submit to this Honorable Senate the rationale for providing this criteria is because it is commonplace, Mr. Vice President, which international reports substantiate that operators can set up shell companies which do not fit the ordinary brick and mortar description of a business. As we all know, these shell companies can present itself in various forms, and they can be used, as we also know, for tax evasion, corruption, money laundering, to name a few. I may also respectfully submit to the Honorable Senator that in 2018, in a report entitled An Overview of Shell Companies in the European Union, this provided an explanation, Mr. Vice President, to what is called special purpose entities. This is a third type of shell company, as we all know, which are entities with no or few employees, or no physical presence in a host economy, and whose assets and liabilities only represent investments. So, to the Honorable Senator, this is why within the bill we have prescribed the restriction on the number of employees required, because we are ensuring that we are also consistent, and we are not oblivious to the fact that shell companies is a reality in Trinidad and Tobago, and it is one of the battles that, as a government who's aimed in fighting white-collar crime, that we would have to tackle. If I may also respectfully take the Honorable Senator to Section 535(2) of the Kenya Special Economic Zone Act, which was one of the comparators that we relied upon in the drafting of this particular bill. It also has a similar provision. So we are not deviating, in other words, to the Honorable Senator, from the norm. Rather, we are not legislating by merely the toss of a coin. We have done our homework, and we are relying upon international comparators in the establishment of this particular zone. There are other things I wish I could have had the opportunity to respond, but again, for the interest. Mr. Vice President, can you tell me how much time again I have?
End at 11:43. About 10 minutes.
Oh, wow. Okay, so so quickly, if I move on, to the Honorable Senator, Mr. Timal, I recall the question was asked, how would legal action and measures of enforcement be dealt with against an unincorporated entity? Clause 6, the authority says that the authority shall have the following powers to take enforcement measures in the event of any non-compliance or a breach of this act or terms and conditions of a license. Now, Mr. Vice President, by definition, an unincorporated entity is one who does not have, as we all know, a separate legal entity from its members. Therefore, while the entity, respectfully to the Honorable Senator, while the entity cannot sue or be sued, the owners and operators can be sued. And if for the record, I may respectfully take this Honorable Senate to the case of London Association of Protection of Trade versus Greenland Limited. It's a Court of Appeal case that would have actually identified, and it's one of the locus classicus on how you treat, at least litigation-wise, with unincorporated companies. So, I mean, there were other things I wish I could have offered an explanation for, but I'm sure my colleagues would have. But I hope that, adds some clarity to the Honorable Senator. Now, Senator Paul Richards made some pertinent contributions, which I would like to respectfully offer an explanation for. Senator Paul Richards focused on the lack of regulatory and monitoring framework. So, for example, he made many of these economic zones become a dumping ground for contrabands and fake products, illegal transshipment of contrabands and goods, services, a lack of transparency and accountability mechanisms. And this, I believe, is a very pertinent concern, right? Because you don't want, things running afoul within the zones. But if I may respectfully take the Honorable Senator to Section 45 of the Customs Act 7801. This contains, of course, a comprehensive list of items that are prevented from being imported. Clause 65(1) in the bill that appears before us, Mr. Vice President, it states that subject to the provisions of this Act, the Customs Act and the Excise General Provisions Act shall apply in the zone to the extent required for the controller of Customs and Excise to carry out his obligations. Clause procedure and this is 65(2)(d) of this bill says efficient procedures and practices to be applied for goods imported from customs territory to a zone and exported from a zone in a customs territory. So I hope this answers the Honorable Senator's concern, right? The Honorable Senator, Mr. Vice President, also made the point of the migrant workers. And that is a very critical point because the Honorable Senator said we also need to be very mindful and careful about ensuring that labor practices in these free zones are in line with our labor laws in Trinidad and Tobago and in relation to migrant workers. Now, I had the benefit of sitting alongside the Attorney General recently in the United Nations Periodic Review. And certainly the issues of migrants even came up, and I know that at the Troika recommendations, the Attorney General did note some of the recommendations that were presented to us. But, Mr. Vice President, if I may respectfully, on the issue of migrant workers, if I may respectfully take this Senate to the International Labour Organization, the ILO standards, that governs this area, as well as the government, I want to put on the record, remains cognizant of the need to offer protection to the vulnerable and working class population. Now, the International Labour Organization, Mr. Vice President, the functions of the ILO include the development and promotions of standards for national legislation to promote and improve working conditions, standard of living conditions, and a whole host of other things, which, of course, because of time, I cannot get into. But we are hoping that, again, with the interoperability of laws that would exist, this zone certainly does not exist in a silo, and other existing laws would, of course, be able to operate. So as it relates to the migrant, I could respectfully take the Honorable Senator to that particular, that International Labour Organization. The ILO. So that, of course, in the interest of time, there's so much more I wish I could have contributed, but I can't. At least to add a little more, my contribution, as I started off by saying, I would have also wanted to focus on the role of inspectors and if I don't know if time would permit, offenses that are created. Now, why I'm focusing on inspectors, Mr. Vice President, to do so, I have to respectfully delve into Clause 67 and 70. But prior to doing that, I want to respectfully look at Clause 53(5) of this bill. Now, 53(5), and I'm sure my colleagues, we all have the bill before us, so I wouldn't read it I wouldn't read it from the bill. What this does, Mr. Vice President, is that, in essence, what it's saying is that the licensee is giving consent upfront to the inspector to carry out his duties to ensure there is compliance with the SEZ bill. The powers of the inspectors are restricted to that set out as we go further down in the bill in clause 70. Now, this is a license, so it is simply, Mr. Vice President, based on the law of contract as well. And what it does, Mr. Vice President, is that it creates a relationship in
Minister,
law.
you have 5 more minutes.
Thank you, Mr. Vice President. It creates a relationship in law between the licensee and the licensor in the granting of the requisite license. Now, why I believe this was important to focus on the framework that we created in Chapter 9 of this bill, the inspectors, is because of the roles of the inspectors, right? They are really the ones who would be ensuring compliance with all of the provisions that exist within the bill. And therefore, their role and function is critical to the smooth operation and the success of these zones and persons more so being compliant. The roles of the inspectors, just to name a few, Mr. Vice President, it is stated in clause 66(1), they are able to conduct inspections. The inspectors will embody a high level of competence as prescribed in the legislation. They will be trained and they will have the requisite qualification established by the authority, and that is in clause 66(2). Now, how is enforcement done, Mr. Vice President? The government, of course, we understand that we must continue to protect the Section 4 constitutional rights of citizens, and therefore, as responsible legislators, we understood in the creation of this regime, we had to focus on what was the legitimate aim of the creation of these inspectors. And I can justify respectfully to this Honorable Senate the justification in the creation of in the creation of these inspectors to dismiss any doubt that any persons may have on the issue of constitutionality and the roles and functions of these inspectors. I may, for the record, some of the legitimate aim in the creation of this regime, Mr. Vice President, was for ensuring that Trinidad and Tobago is consistent with the requirements as currently set out, as I would have stated in the OECD, the BEPS, the EU, and other pieces of existing treaties or legislation that exists. Another legitimate aim was to enhance the attractiveness of business climate in Trinidad and Tobago, while also, of course, protecting the domestic revenue base to the greatest extent as possible. And another legitimate aim in the creation of this inspector regime, one which I may respectfully submit, is to regulate supervised SEZs to increase the economic and social impact of economic zones in Trinidad and Tobago. So, Mr. Vice President, I can, certainly say that we have ensured that we have crossed our T's, we have dotted our I's, we've ensured that this bill has not, even with the creation of inspectors who can then be accompanied by police officers with or without a warrant. I'm sure there are might be certain points the Attorney General may probably develop. It is fair to say that as I said, we have crossed our T's, we have dotted our I's, and we have not tripped over any constitutional rights of our citizens of Trinidad and Tobago in the creation of these inspectors. Now, there are several offences, Mr. Vice President, created throughout the length and breadth of this bill. Clause 73, for example, creates a clause which I call the false information offence. We have a breach of confidence, 74(1), which I call the confidentiality clause. We have 75(1), which creates another offence, holding oneself out to be a licensee. We have other offences that are created, and then, of course, we have the whole administrative fines, which are dealt with in clause 76. Now, why I'm mentioning as I conclude my contribution, these offences is because, again, this is yet another attempt by this government to continue our fight against white collar crime. We're not oblivious as to what can transpire in the zone, and hence, my colleagues, all of us who have the benefit of looking at the bill, we can revert to these clauses which creates these offences And of course, there are fines and penalties that are attached that the bill goes on to speak about. So, Mr. Vice President, in conclusion, I want to congratulate again the Minister of Trade and Industry for doing the work that was necessary in order to create this bill that appears before you, the people of Trinidad and Tobago, with the intention of only serving all manner of people, Mr. Vice President, without fear or favor. I thank you, Mr. Vice President.